Once the case is filed, the next thing that you have to be concerned about is what we call the quote meeting of creditors. Reason I'm putting quotes around the term meeting of creditors is that probably in most cases the last thing you're ever going to see at a meeting of creditors is a creditor. What you're going to see will be your bankruptcy attorney. I'll certainly be with you there, and you're going to see the bankruptcy trustee, or in the case of a Chapter 13, you're going to see a staff attorney who works for the bankruptcy trustee. But whether it's a Chapter 13 or Chapter 7, the questions tend to be very similar. You're going to expect that you'll be asked to state your name. You're going to have to provide proof of your Social Security number and a picture ID. The trustee is going to check those to see that they match the information on the bankruptcy petition. You'll be asked, did you sign the petition, the statements, and the other documents that you filed with the court? Normally that would be a yes. You'll be asked, did you read the papers before you sign them? Of course that would also be a yes. Are you personally familiar with the information in the papers you signed? Is everything in those papers true and correct? Do you have any changes or additions you'd like to make? Well, lots of times there are changes and additions. It's not unusual that either something has changed or there's some sort of a little error somewhere in the paperwork. A lot of times it's not necessary to file an amendment of any of the documents. We just get to tell the trustee at the hearing what the additional information is. They're going to ask, are all your assets listed? They're going to ask, are all your debts listed? Did you list all your creditors? Have you ever filed a bankruptcy before? If you have filed a bankruptcy before, I'll probably have in my file the information on exactly when you filed it and even what the court file number was, and of course what kind of bankruptcy it was. This is a question that comes in different forms, and it's, have you sold or transferred or given anything away to a close friend or family member? The question varies. Some of the trustees are going to say, have you done it within the last 1 year? Some will say, have you done it in the last 2 years? They might go back as far as 6 years. The bankruptcy trustee can look at transfers that you've made. Under the federal bankruptcy statute, they can look at transfers you've made in the last 2 years, but there's a state law that lets them go all the way back 6 years. This is an issue that we would have seriously looked at before we filed the bankruptcy. They'll ask you, do you own your home? If the answer is yes, it's how long have you owned it? And they want to know, have you refinanced it in the last year? There's a number of things that the trustee just might uncover if that's a yes. If the mortgage has not been filed before the bankruptcy is filed, then the mortgage doesn't count. And you've got a house that's free and clear, and that's a whole nother bag of potatoes from having a mortgage on your house without a whole lot of equity. There's always a question about claims. Do you have a claim against anybody? A car accident claim, a workers' compensation claim, a dog bite claim, a discrimination claim, that's an asset. Have you made any payments in that total within the 90 days before you filed more than $600 to any unsecured creditor? In other words, has any unsecured creditor gotten over $600 from you through voluntary payments that you've made in the last 90 days before filing the case? Reason for that question is that if you paid an unsecured creditor over $600 in the 90 days before we filed the case, then we have what they call a preference. A preference is an asset. A preference is a situation where the bankruptcy trustee gets to go to that creditor who you paid and demand that the money be returned not to you but to the bankruptcy trustee. Most bankruptcies are Chapter 7, so that's, if you're watching this video, most likely you're thinking about a Chapter 7 or already have filed a Chapter 7. In the Chapter 13, 341 meeting of creditors, the questions are pretty much the same, or at least they're very similar, but the emphasis isn't so much on finding assets. It is on trying to figure out whether the income and the expenses are correctly listed,